Former President Jacob Zuma's 2012 decision to recognize Prince Toni Mphephu Ramabulana as king was nullified by the Supreme Court of Appeal in 2019. The SCA ordered that the recognition and appointment of Toni Mphephu Ramabulana as king was unlawful and inspired by gender discrimination. In 2016, Princess Masindi Mphephu successfully interdicted Toni Mphephu Ramabulana coronation as Vhavenda King. The case became an epitome of fundamental clashes between customary law and constitutional principles. The dispute was referred to the Polokwane High Court to assist the Mphephu royal family to follow due legal processes when they identify an heir to the throne. Limpopo Judge President George Patudi said the case was long and complex.
Not going to be an easy exercise. I know we are required in terms of the judiciary code of conduct that we must produce judgments within 3 months. This might not necessarily be the case because this has been a long and very complex case that affects the lives of the people of the Vhavenda community. Therefore, we'll have to go back to the drawing boards and assemble all the facts, the arguments, and the evidence, and see whether we come to, at the end, produce a well-reasoned judgment. To that extent, it is clear that we are unable to come to any conclusion now. So in the circumstances, the order is that judgment in this case is reserved.
Meanwhile, Princess Masindi's lawyer, Advocate Alan Dodson, and Toni Mphephu Ramabulana's lawyer, Advocate Shonisan Ravere, have insisted that the office of the president should carry the course of the sitting. This was in response to the submission brought by the lawyer representing the office of the president, Advocate Zinzila Matebese. Matebese believes the presidency cannot be held liable for the cause as its decision to recognize Toni Mphephu Ramabulana as king was nullified. Dodson and Ravere agree that the president's decision is the cause of the kingship dispute and that he remains a key witness.
After all, it was the unlawfulness of the recognition decision that created the need for the court's involvement. That's exactly where we're sitting. And let us also recall at the beginning of my argument where I pointed out two respects in which not the beginning, at the end of my argument when I stood up yesterday morning, two further respects in which the president got it wrong. He got it wrong in that he also, not only does he have to check that it was compliant with customary law, he also has to check it against the Constitution and the Act. And the SCA said, you should have checked that Section 2A4C was being complied with, and you didn't. You failed to consider a relevant consideration under Section 6 of PAJA, and that's one of the reasons I'm setting this aside.
He knows that the remedy has not yet been decided. He should have come, participate, because he already knows that if there will be a president, maybe for the first time, there will be a king for the first time in the history of South Africa, who will have been appointed by God instead of the president.
Judgment in the matter will be delivered on a date yet to be determined. Rutendo Bobori, SABC News in Polokwane.